Hello, and welcome to the 538 Politics Podcast. I'm Galen Druk, and today we're doing things a bit differently. Because President Trump plans to announce his pick for the Supreme Court Monday evening, we're going to record our regular roundtable podcast on Tuesday. But to tide you over in the meantime, we have a special episode for you today. We're going to take a look at what's ahead in the debate over partisan gerrymandering. If you've been listening to this podcast for a while, you know that it's a topic we've covered plenty, particularly in a series we did called The Gerrymandering Project. And if you haven't heard it, you can check it out by searching The Gerrymandering Project wherever you get your podcasts. Anyway, after the Supreme Court ruling last month on the big gerrymandering case out of Wisconsin, I wanted to follow up with the people involved, and now that Justice Anthony Kennedy is also retiring, things have been shaken up even more. So we're going to have this conversation in two parts. First, we're going to look at the national level and the cases in the pipeline to the Supreme Court. And then we're going to look at the state level. With Justice Kennedy out of the picture, maybe more and more focus is going to be placed on the state level. So here with me to talk about the national level and the Supreme Court is Ruth Greenwood. She's senior legal counsel at the Campaign Legal Center and is representing plaintiffs in the partisan gerrymandering cases out of both Wisconsin and North Carolina. Hi, Ruth.
Hello, good to be with you.
Good to have you. And actually, for the sake of transparency, we are having this conversation for a second time. We originally recorded this conversation before Kennedy announced his retirement. So I think it's fair to say that things have changed a decent amount since the last time we spoke. How, in your eyes, have things changed?
Yeah, I mean, they have and they haven't, right? Justice Kennedy had never actually got to the point of saying, here's a test for partisan gerrymandering. I know that back in 2004, he had said there might be a test out there, but John Roberts wasn't on the court then. And so even though a lot of people thought that Kennedy was our big hope, I do think that the fact that we had at least 7 justices say that in Wisconsin we can go back, give some more information about district-specific standing, and then they'll hear the merits, is potentially a good thing. I am an optimist, so I always try to keep my hopes up. I think that the justices have all said on multiple occasions that partisan gerrymandering is a real harm. You know, they've understood our theory that this is about vote dilution. So, you may have said before that we were going for Justice Kennedy. You know, we were always trying to get as many judges as we could. And this time, I guess we won't have him there, but there are others.
And so just to clarify for listeners who aren't familiar with the Wisconsin case, essentially it made it to the Supreme Court, but then was sent back to lower court to fix some standing procedural issues, essentially, in lower court, and then it could go back to the Supreme Court. And we can get into that and what your next steps are. But for now, I do want to hone in on what a court without Anthony Kennedy means for partisan gerrymandering. I have talked to, Nick Stephanopoulos, your husband, who's also involved in the case, who helped develop the efficiency gap.
He's not as optimistic as I am. The whole way through, any interviews, it's always Nick being like, oh my goodness, I'm not sure if we have a chance. And me being like, yes, we can do this. So somehow we balance each other out.
And I've talked to other lawyers who have worked on the case, one of the plaintiffs in the case, and everybody always talks about Anthony Kennedy. And Anthony Kennedy said this about the First Amendment and how it may help us in this case. From covering your case, get the sense that it was tailored to things that Anthony Kennedy had said. So do you have to reconsider what arguments you're making at all? Where is your head at in terms of adjusting to the reality that he won't be on the court?
Yeah, I mean, it is true that when Nick wrote the original article that a lot of our theory was based on, he thought of himself as writing specifically for Justice Kennedy. But as we've gone along, I think that we have got more information from the other justices. And so, as I say, it seems as though I wouldn't usually say the term swing Justice Roberts, but he may well be a swing justice on this issue. We hadn't heard really anything from him in the past about partisan gerrymandering. And so now he's said, look, you can come back to me with more district-specific evidence. I did notice in the Kagan concurrence, she talked about First Amendment associational harms. There had been some speculation in the press that maybe that was a suggestion to us of what Justice Kennedy might want to hear. And if that's the case, then I guess that's less relevant if it was specifically about Kennedy. At the same time, Chief Justice Roberts likes to write about the First Amendment too. So it may be that Kagan, along with others, have some interest in hearing more about First Amendment party associational harm. So, in terms of going forward, we still think it's a gerrymander, right? There are lots of different ways you can explain the problems of gerrymandering, and I guess we're going to explain them at the district level, at the statewide level, in terms of individuals, in terms of the party, just to really make sure if anybody has a particular view on the problem of gerrymandering, we will give it to them, and then we'll see where the court comes out in terms of what you actually have to prove going forward in other cases.
So you're going to kind of pile up as much evidence and as many arguments as you can, obviously knowing less about maybe what the justices on the court now think. But do we have any idea of what Roberts thinks about partisan gerrymandering?
We don't have a good idea. I mean, we do have a sense from his racial gerrymandering cases that he likes to look at individual districts. And that seems to be the theme of what he wrote in our case as well. And so I think giving more of that individual district level information makes sense. And maybe that's just the case that, you can say, look, overall one side's harmed or another, but maybe you need to feel like just like how you talked with our plaintiff, Marilyn Donahue, you need to go to where she lives and say, here's one side of the district and here's the other side. And this is why it's now two Republican districts, not a Democratic and a Republican one. So I think we have that sense from Chief Justice Roberts. And I think also look, I don't know him, but what I read in the press suggests that he cares about the institutional, reputation of the court. He said in our case, one of the questions was, isn't this just going to look like the court calling elections for Republicans or Democrats? And I guess our point was, well, as long as one side is gerrymandering or the other side, then leaving it to continue really is putting your thumb on the scale already. At the moment, they've put their thumb on the scale for Republicans in Wisconsin and for Democrats in Maryland. We hope that once we go back with the evidence explained in a way that they want to hear it, that they are able to say, yeah, let's put this back to a level playing field, and then the voters can decide.
Essentially, what the court said in an opinion that Roberts authored was individual plaintiffs cannot sue to have statewide maps invalidated, is essentially the new information that you got a few weeks ago at the Supreme Court. So what are you doing now to respond to that?
Yeah, I mean, I want to be a little bit careful. I want to preserve my attorney-client privilege. But essentially, we're telling the stories of our plaintiffs. So the court mentioned in its decision, or John Roberts mentioned in the decision, that what we had explained as a harm for people like Marilyn Donahue was the sort of thing that they would like to see discussed in trial testimony. And so we are going to make sure we go around Wisconsin and tell the stories of all the individual voters that were harmed. Essentially they were put in a particular district by the 2011 map, Act 43, and they could have been in a more fair district. That was something that Chief Justice Roberts referred to. Let's see the hypothetical district that's more fair. So I think we're going to show these are the places that it's not fair and this is how it could have been done differently. And that means that there are some places that potentially, we won't challenge. It is Democratic, it would always be Democratic, or it is Republican, it would always be Republican. It's the places on the margins where there's the greatest evidence of packing and cracking that we want to focus on.
In terms of moving forward with your case, Justice Roberts said something else during the oral arguments that was probably not exactly what you wanted to hear, but he called the efficiency gap, or, using statistical methods to show partisan gerrymandering, sociological gobbledygook. Obviously, the efficiency gap is a significant part of your case. And for people who don't know, the efficiency gap is essentially showing the difference between how many seats you would expect a party to get based on their votes versus how many they actually get. So Justice Roberts called that sociological gobbledygook. What do you think about continuing to use the efficiency gap in your litigation?
Look, I think it's relevant because the point is that it looks at historically what seats would you expect given the vote. It looks at 40 years of data. It can compare one state to another. The situation that perhaps the Supreme Court hasn't considered because it hasn't come before them yet is, there are 99 districts in Wisconsin. Roughly 60 of them are won by Republicans. If we imagine a 50-50 vote, then say about 10 more districts should be won by the Democrats. If we were to challenge 15 or 20 areas and say there should be an additional blue district here or there, it would be crazy if the court said, sure, here, have 15 more districts. That would be us asking for and getting a Democratic gerrymander, and that's never been what this is about. I think at some point you need to look at overall fairness in the state, even if you identify harms in particular areas. And this is exactly what the court does in the area of minority vote dilution, where you say, look, we think we should have an extra district that's majority minority to protect the interests of, say, African-American voters. The court then also has potentially a proportionality test there where they say, well, what's the proportion of African-Americans in this state? Now, what we are suggesting isn't proportionality, but we do think there are statewide measures of fairness that you would want to look at. So I think it has been relevant and is still relevant.
But you're not changing your overall strategy of how you're arguing this. I mean, do you plan on de-emphasizing the efficiency gap or other statistical measures when arguing this in front of, future swing Justice Roberts? Where is your thinking on that?
I can't really comment on strategy too much. Obviously, we need to decide that internally, and to some extent, it hasn't all been entirely decided. But as I say, I think that the evidence of the efficiency gap is what we still feel of as a harm, right? As Bill Whitford said, just because the court wants, you to show jump through one hoop or jump through another, the harm is real, right? Bill Whitford goes around the state trying to raise money and get candidates on board and register voters, and his ability to get policies that he wants through the state legislature are harmed by the gerrymander. We can identify that harm through the efficiency gap. We can also identify that through looking at, hypothetical alternative districts and where you could have a red or a blue district and what those percentages would be. I sort of feel like all of these are different ways of describing the same phenomenon, which is an unfair redistricting plan.
So the Supreme Court sent two cases back to lower court, the Wisconsin case, which we've been talking about, and also the North Carolina case. When can we expect both of those cases to reach the Supreme Court again?
So I'm also an attorney in the North Carolina case. In that case, our court has moved pretty quickly. They've already issued an order asking us to comment on scheduling by July 11. We think that in that case, we already had a whole bunch of hypothetical alternative districts, and we have plaintiffs all over the place. So we think that we just need some very limited additional findings, essentially, from the court with respect to standing. And so then that can go back up to the Supreme Court, which suggests that we could get there this term. It depends a little on exactly, what evidence our district court wants to hear, how quickly they decide, and how quickly it's appealed. But it could go back up pretty quickly.
And then in terms of the Wisconsin case, what kind of timeline are we looking at?
So in Wisconsin, we don't have as much evidence of, hypothetical alternative districts and percentages and so on. And also we have 12 plaintiffs, but there are 99 districts. And so we think we need to open up the evidentiary record a little more there, probably amend our complaint. My guess is that means that we are talking about months before the record closes and we get a decision. And if we don't have a decision, this year, for example, in 2018, then we probably can't go back up to the Supreme Court. So my guess is that case won't go up until the 2019 term, at which point we may have had a decision from North Carolina.
To wrap things up, I want to go back to Anthony Kennedy for a moment. I've been covering your case in Wisconsin now for about a year, and of course, he was a big focus, and people told me often that they thought, Anthony Kennedy really cares about this issue, and we think that he is going to be the one to make partisan gerrymandering or extreme partisan gerrymandering unconstitutional. Now that he's retiring, and retiring after having the opportunity to say that partisan gerrymandering could be unconstitutional and then not taking that opportunity, do you think that he ever really cared as much about this issue as kind of people thought he did? What do you make of how this all played out in the end?
Oh, my goodness. If I knew the mind of Justice Kennedy, I would be a rich lady. No, I don't know. I mean, I agree with you that we had thought that he showed an interest because of what he had said in 2004 in the Veith case and to some extent 2006 in the Lulat case. But as you point out, right, we gave him the case on a platter. In fact, there were two, right? There was the Maryland case about Democratic gerrymanders and the Wisconsin case about Republican gerrymanders. And he, declined to get involved. So, maybe it never was Justice Kennedy that was going to be our great hope. Maybe, in fact, Justice Roberts, who's clearly taken an interest in this, right, wrote the decision for the court. Maybe all of the time he was our hope. I don't know. I am remaining hopeful. And I guess this is one area where maybe Justice Kennedy retiring doesn't make such a difference because he seems as though he wasn't helpful before. So if he's not there, then we're not missing much.
Fair enough. Ruth, thank you so much for joining me today.
Thank you very much. It's a pleasure to be on.
Ruth Greenwood is senior legal counsel at the Campaign Legal Center and is representing plaintiffs in 2 federal partisan gerrymandering cases. Okay, so as we've discussed here, a lot of the attention on partisan gerrymandering has been at the federal court level, essentially what's in the pipeline to the Supreme Court. And that's, of course, because reformers, if they can get it, would like a Supreme Court ruling so that it becomes the law of the land. But there are also lawyers and activists focused on the state level. And perhaps now that Anthony Kennedy is gone, we may see an increasing focus on state-level litigation and ballot initiatives. And here with me to talk about that is Michael Lee. He's senior counsel for the Brennan Center's Democracy Program and focuses on redistricting, voting rights, and elections. Hey, Michael.
Hey, thanks for having me.
First, let's talk about state-level courts. Why shift focus there? Is there a sense that you may not get the ruling that you're looking for from the Supreme Court?
Well, partisan gerrymandering is an issue that's long befuddled the federal courts, and they've had a hard time actually coming to a rule, and it remains to be seen where the federal courts go. That's prompted people to look at state courts and state legislatures as a possible second front on the war against partisan gerrymandering. And earlier this year, we had a really stunning victory out of Pennsylvania, where the Pennsylvania Supreme Court struck down the state's congressional map and ordered it to be redrawn. And the result was a map that's much more responsive to electoral swings. And so, I think that sort of encouraged a lot of people to look at state courts because there is this rich state constitutional tradition that a lot of people have ignored up until now.
Is that the first time that there was a ruling like that out of a state Supreme Court?
That's the first time that you've had a ruling that wasn't based on a really specific provision of the state constitution. The Pennsylvania ruling was based on more general provisions of the Constitution that guarantee free and equal elections. And so that's the first ruling of that sort.
When it comes to that clause, free and equal elections, is that unique to state constitutions? And if so, how many states have clauses like that?
11 states, including Pennsylvania, have clauses that guarantee free and equal elections. In addition, all states have something analogous to the First Amendment and something analogous to the Equal Protection Clause. And so there are lots of avenues in state constitutions that you could potentially pursue. And as I said, there's a really rich constitutional tradition. A lot of state constitutions come up later than the federal constitution. A lot of them were adopted in the progressive era or in the 1960s or 70s. And so there are a lot of potentially really good progressive gems that are hidden in a lot of those that people just haven't been using.
I have to ask, how much of the optimism surrounding state courts ruling partisan gerrymandering to be unconstitutional is based on how those state constitutions are written versus the makeup of state courts? Like, the state Supreme Courts happen to be more liberal, so reformers think they'll have a better chance of getting the court to rule that partisan gerrymandering can be illegal.
Well, it's a little bit of both, right? I mean, you obviously need, good precedent and good, legal provisions in your state constitutions, but you also need good courts. And, one of the frustrations at the federal level has been you've had a very conservative court that sort of hemmed and hawed and in some ways sat on its hands with this issue. And you've had, in Pennsylvania, for example, a much more progressive court willing to sort of push the boundaries of the law in new ways and to think creatively. And so, it does matter what kind of court you have, but, you also have to look at the bones that you have in the state constitutions.
The big challenge for the Supreme Court has been finding a standard that can show when regular redistricting becomes extreme partisan gerrymandering, where they can draw the line in the sand and say, beyond this point, you cannot go. On the state level, we have one example, I guess, Pennsylvania. Are they finding clear standards? I mean, how are they making these rulings? If we don't have a clear standard on the federal level, are they finding one on the state level?
Well, they're starting by asking what values are embedded in their state constitutions. And in Pennsylvania, the court said, one thing that we in our state constitution don't allow is entrenching representative power. And it then looked at lots of evidence about whether that was happening in Pennsylvania, including evidence similar to what was used in the Wisconsin or the North Carolina cases. And so, they were able to identify a constitutional harm, artificially entrenching representative power, and then they were able to use a lot of evidence, including statistical measures, but also the shapes of districts, also, evidence from the legislative process to say, that is what's happening, and we believe that this map is unconstitutional.
Although one criticism that I've heard in the Pennsylvania case is the ruling was largely based on conventional principles about what a district should be: compact, contiguous, respect municipal boundaries. If you read the opinion, it was a lot of emphasis on that. But then when the Supreme Court instituted a new map, it seemed like the emphasis was really on partisan symmetry and making sure that the results of elections reflect the vote share. If that was what the court actually wanted to do you think the opinion reflected that? I mean, is that a fair criticism?
Well, the court looked at whether counties and boundaries and municipalities were split apart, in part as evidence that something was going on. So what the court said is traditionally, this is what we have done. You deviated quite a bit from that. So that seems to be probative evidence that maybe you were doing something different or wrong this time.
But if state courts focus on compactness, contiguity, respecting municipal lines, etc., do you think they risk misunderstanding the partisan gerrymandering issue? Because if you look at what happened in Pennsylvania, right, Republicans in the legislature said, okay, point taken when they first struck down the map, we're going to draw a map that more clearly respects county lines, and they did that, but it was still, when it comes to actually like packing and cracking of voters, clearly benefited Republicans, right? You can still respect county lines while drawing a map that benefits one party pretty clearly over another.
Absolutely.
So, I mean, do you think that if states focus on this, compactness, contiguity, those kinds of things, that partisan gerrymandering may not really be addressed?
I think courts will have to look at the big issue, which is whether maps are electorally responsive or whether they sort of artificially lock in an advantage for one party over the other. And things like compactness and contiguity and such can be evidence that something is going wrong. In the same way, if I'm getting up in the middle of the night to have to use the bathroom a lot, maybe I have diabetes. But it's not, in itself, getting up to go to the bathroom in the middle of the night is not a problem, but it may be symptomatic of something else. And in the same way, not having compact districts, not having contiguous districts, not respecting political boundaries may be symptomatic. And so it's not the harm itself. And if courts start to think that that's the harm itself, then they're going down the wrong path. But if they understand correctly that that's just probative evidence that there might be harm, which is something like artificially entrenching representative power, then they're on the right path.
I mean, there aren't state constitutions that specifically spell that out, right? So that's just going to be up to the interpretation of each individual state Supreme Court, right?
For the most part, that's right. Some states have a ban on partisan gerrymandering, but that's very rare.
And that's usually because of a ballot initiative or
that's
something
right.
like that. They've instituted a commission, an independent
That's
commission.
right. It's a growing trend, but it's not something that we put in constitutions in the 19th century or even in the 60s or 70s.
What's the strategy here? Do you know reformers that plan on bringing challenges to maps based on state constitutions now or before the next round of redistricting?
It wouldn't surprise me to see some suits brought in state court just because, even though it would only affect one election at this point, it's important to reset the maps because in the next round of redistricting, the old maps are oftentimes used as the starting point for new maps, and the justification you have is, we were just trying to make as few changes as possible. So if, again, you have a favorable state constitution tradition, and a good court.
So what states are we looking at specifically where we might see those kinds of cases?
North Carolina is an interesting case, although, the congressional map was struck down. In federal court, North Carolina has a very good Supreme Court. It has a very...
and by good, you mean liberal?
A court that I think would go... that would rule favorably on a partisan gerrymandering claim, right? And, it does have a Democratic majority now in part because, again, North Carolina is a 50-50 state. It elects Democrats and Republicans at the statewide level. And, North Carolina has a very good court. Potentially New Hampshire, maybe, Michigan, perhaps, if the court changes a bit. Michigan has a very politicized court right now, but the elections this year, 2 of the justices are up, and so the composition of the court could change a bit there. And so those are a couple of the states that I would be on the lookout for.
And do you think if we don't see a Supreme Court ruling on partisan gerrymandering by the next round of redistricting, 2020 is the census, and then 2021 is when the maps are redrawn, do you think we'll see a lot more of these state-level claims in, 2021, 2022?
Potentially, especially if there's nothing on the federal level, right? Because gerrymandering is getting worse. It's getting easier to do. It's, getting easier to be very pernicious and to lock in very skewed maps, in part because of big data, in part because of technology, and we just know a lot more about voters now than we ever have, and that makes it easier to draw really skewed maps, and
and voters are more partisan.
And voters are more partisan, right? That's our partisan identities are harder, and so all of that goes in and makes it possible to gerrymander more extremely than we have in the past. And if that happens, then I think people will look for every avenue to challenge those.
And so another avenue that I want to talk to you about is legislation on the state level. I guess potentially the federal level, although there's zero indication, I think, that Congress is ready to pass some kind of redistricting law.
Not this Congress.
Yeah. So on the state level, there are kind of two ways that the laws can change, either through a ballot initiative, which is where, activists collect signatures, get a law put on the ballot that voters can vote up or down. And then the other option, of course, is state legislatures can pass laws. How common are either ballot initiatives or state-level legislation at this point?
So about half the states allow ballot initiatives, and almost all reforms that have been successful thus far have been pursued through ballot initiatives for obvious reasons. Lawmakers are very hesitant to give up the power to redistrict, especially to redistrict their own seats, and so where people have been successful, it has largely, but not exclusively, been through ballot initiatives. And that's changing a bit. In Ohio, the legislature did pass a very good series of reforms in 2014 and another set this year, which voters approved in May. And so it is possible to do reform through other channels. And, we're sort of at an interesting point politically where, there actually may be incentive for legislatures to deal in ways that they haven't in the past. And that's because there is legal risk through the courts now that they didn't have before, but there's also political risk, right? Because the way that you do these extreme gerrymanders is that you draw districts, not that your party wins by 80%, but that your party wins by 53, 52%. And so those districts are potentially vulnerable in a wave. And so parties, whether they're Democrats or Republicans right now, don't know who's going to be in charge in 2021. And so it's almost this perfect Rawlsian sort of thing where you don't know who's going to be in charge. And so you actually have an incentive to produce a fair system.
And how many states are taking the ballot initiative path right now?
So right now there are going to be 4 measures on the ballot or likely 4 measures on the ballot in November. In Utah, Colorado, Missouri, and Michigan. The Michigan ballot effort is being challenged in court. It's at the Michigan Supreme Court right now. But if the Michigan Supreme Court greenlights it, then there'll be 4 ballot initiatives this fall.
I can tell from the feedback that we get from listeners and just reading the news in general that gerrymandering is, in a sense, having a moment in, I don't know, I don't want to say pop culture because it's a little wonky for that, but people are increasingly interested in gerrymandering. I mean, is that being reflected on the ballot? Is it normal that we see this many ballot initiatives in one election?
No, it's definitely growing, and the number of efforts around the country to get ballot initiatives in the future or to reform the process through the legislature itself is just phenomenal. Michigan started off with a single Facebook post the day after the 2016 election. A woman named Katie Fahey in Michigan posted and said, "Hey, I want to solve this problem. Anybody interested?" And the whole effort that collected 500,000 signatures grew from that single Facebook post. And when you go around the country and you talk to people, everybody responds to gerrymandering now. It's a word that people use. And that's completely different from just a few years ago, where if you were trying to do poll testing around gerrymandering measures, nobody knew what gerrymandering was. Talking about gerrymandered maps didn't move the electorate one way or the other. Now everybody understands it, and they respond, whether they're Democrats or Republicans. And you see that in Ohio, you see that in Michigan, where people would go down the street in very mixed partisan neighborhoods, and every single person would sign the ballot initiative.
Let's talk a little bit before we wrap up about Missouri's initiative. It's pretty unique. I don't think this has ever been done before. They are creating a state demographer position who is supposed to use the efficiency gap to create maps. I mean, do I have that right?
You have the basics right. Yeah.
Okay.
Yeah.
What do you think of that? I mean, how is that supposed to work out?
The idea is that, we should have somebody whose job it is simply to draw the maps. And, it's unique in a lot of ways. Iowa uses a somewhat similar method in the sense that it uses civil servants to draw maps, and those are then approved by the legislature. But, Missouri's takes that a step further by requiring use of a particular statistical measure to gauge whether maps are fair or not.
And very clearly use political data and make decisions based on that political data. I mean, which elections do you even, I guess they probably write this out in the law, but you run into problems of which elections do you even use? Voters change their mind. Do you think that is a real challenge, or is that just noise?
It's a fair approach to the problem, and, it's a fair policy choice, a decision that the voters of Missouri can make. It does mandate a particular type of map. It's outcome determinative in that sense, which is different than some of the other reforms, which are more about the process, just creating a fair process and having some rules around that. But, they're mostly about the process, right?
And so this is saying you have to have a map that essentially elects representatives as you would expect based on the share of the vote that each party gets.
Yes, with some constraints. I mean, it's a little bit more complicated than that, but in general, it sort of does mandate a particular outcome, and that's something that the voters of Missouri, if they choose to, can do.
And that hasn't been done before.
That hasn't been done before.
Do you expect these initiatives to pass?
I think it'll be interesting to see. What we've seen is that wherever redistricting reforms have been on the ballot, whether it's in Ohio or elsewhere, they overwhelmingly pass. Ohio, I think the most recent congressional reform got something like 70% of the vote, which is, extraordinary, right? And the polling around redistricting reform elsewhere shows that it has huge support from Republicans, Democrats, and independents. And so, if these ballot efforts are well organized and well funded, I fully think that a lot of them will pass.
All right, well, let's leave it there. Thank you so much for taking the time today.
Thank you for having me.
Michael Lee is Senior Counsel for the Brennan Center's Democracy Program. That's a wrap for us today. As you can tell, there's plenty to keep your eyes on in terms of what comes next for partisan gerrymandering. And also, as I mentioned earlier in the show, if you missed our series about partisan gerrymandering, you can listen to it by searching for The Gerrymandering Project wherever you get your podcasts. In that series, we travel around to different states and explore the effects of gerrymandering and what reformers are trying to do to change the system. We also have a Facebook group called The Gerrymandering Project where you can ask questions or share thoughts about anything you heard today. So let us know what you think. That's it for today. We will be back with you tomorrow to talk more about the Supreme Court once President Trump picks his nominee. Until then, thanks for listening.